then he's the tribunal, is the judge. And so it defeats the concept of natural justice that says that I shall not be a judge in my own case. In this one, it is defeated. Then, lastly, there is also unclear relationship to alternative dispute resolutions. There is no integration. No integration is provided with mediation, arbitration, or negotiated settlement processes, which could resolve matters more efficiently and with less adversarial impact. What are our recommendations on this? We recommend that the registrar's adjudicatory authority to be limited to specific, well-defined categories of disputes that fall within sectoral expertise and require specialized knowledge, e.g., registration disputes or licensing conflicts. Number two, recommendation number two, with statutory procedural framework. We pray that you incorporate in the Act itself, rather than solely in the regulations, core procedural safeguards, including impartiality standards, evidentiary rules, timelines for resolution, and the rights to representation. Recommendation 3, we also recommend mandatory ADR pathways. Recommendation 4, we also recommended that ensure that appeal rights to the High Court include both questions of law and fact, and that orders of the registrar are stayed pending appeal to avoid prejudicial enforcement. I think that is very, very, very important, because yes, the amendment cites that if one is not satisfied with the decision of the registrar, they can always appeal to the High Court. But we are saying in the law, please include that there should be the questions of law and fact, and that orders of the registrar are stayed. Okay. Then recommendation 5 on conflict of interest and recusal. We pray that you include the recusal clause in it, in this particular section. And then lastly, it is on the ministerial discretion. We are suggesting that limit the scope of regulations to procedure detail, ensuring that substantive jurisdiction and rights are clearly set in the Act. We proceed. Clause 20, we proceed to clause 20, section 56, and this one in particular is on collecting societies. With this one, we are making a proposal, because in this particular section, there is no definition of a collecting society, and it is only left to, I think in this regard, it is only left to constitutions of respective CMOs or collecting societies, but our recommendation is that we recommend an amendment that includes a definition of the collecting society. The rationale for this is that preserving the integrity and purpose of these entities, collecting exists primarily to serve the collective interests of the rights holders by administering and enforcing copyright and related rights. Defining them explicitly as not-for-profit organizations owned and controlled by their member rights ensures that they operate transparently, equitably, and without undue external influence. So this legal clarity will strengthen the copyright system and align Uganda's framework with international best practices. So, and this will anchor, so our recommendation is that we have an insertion of a clause which reads, I beg I read this verbatim. We propose an amendment in section 56 by inserting immediately after subsection 1 the following. A, for the purposes of this act, a collecting society means a not-for-profit organization established for the collective administration of copyright or related rights, which is owned and controlled by the member right holders whose rights it manages, and which operates on the principles of transparency, accountability, and equitable distribution of royalties. That is our prayer for that particular section. Then we move on to clause 25, which is section 67A, and this one is on the annual general meeting. Dear members, before you hear a few of my board members, I have a third company, and these are voluntary workers. They are not salary earners. They are not remunerated. I actually have two more on the other side. I have Director Washington and Director Raymond Mugerwa. They are not salary earners, but the amendment proposes that it mandates that we should, of course, which is understandable, we should have an annual general meeting every after 12 months or calendar year. We are in total agreement. But then for the provision to go ahead and impose that for failure of holding this AGM, there could be, these could be circumstances beyond their own control. But then to say that if we fail to host an AGM, we serve 10 years of imprisonment, and this to every executive member of the board, 10 years of imprisonment or a fine of 50 million shillings. It is really very sad. We find this draconian. These are because if a board fails to hold an AGM, this is an administrative breach. It is not a criminal breach. It is not criminal. Or it's not a criminal offense. So why would I serve 10 years for an administrative breach? Why would I pay 50 million for an administrative breach? Are we trying to say that in the same spirit, if you members of parliament fail to pass a bill, say in your tenure you should serve 10 years of imprisonment? So, but our rationale for objecting this particular provision, one, the Principal Act already has remedies. If you look at clause 70, subsection 7, it says that if the executive committee fails to convene an annual general meeting or fails to give accountability, cause accountability for 12 months, there are no justifiable reasons for the registrar to give them an extension beyond that time limit, then they have automatically relinquished office. That provision is there. But furthermore, still in the Principal Act, there is section 71(3) and section 79. They appropriately impose administrative sanctions, including disqualification and fines, and they reserve imprisonment solely for cases involving willful misconduct, such as fraud or misappropriation of funds. But still, this particular amendment in subsection 3 is against the international treaties that we are looking for to domesticating. So what is our recommendation? We recommend that subsection 3 of section 67A be repealed. The existing enforcement mechanisms within the Principal Act, including administrative fines, disqualification of executive committee members, criminal sanctions for serious misconduct involving fraud or corruption, and other appropriate sanctions, already provide sufficient and balanced measures to ensure compliance with governance obligation. So that means if this has been happening, the point is not with the law. It is the issue is the lack of enforcing the law. Let me give you a highlight on this. How we came into office. I told you we are creatives. I'm personally a creative. I am an actor. I'm also a performing artist. How do I become to be board chair? We were the agitating people who were saying, you people are not holding the AGM. And I used the very provisions I'm talking about. We used the very provisions we are talking about to say that, no, we want a change. This is a company limited by a guarantee. It belongs to all of us, the artists. These provisions are already there. So there is also a challenge of good legislation, but then legislation staying in the books, that the members don't know what their rights are. But some of these provisions are already provided for in the Principal Act. So we boldly stand and say that it will be our prayer to have this particular subsection 3 of section 7A repealed. And we move on to our last observation, which is clause 26, section 74. And this is about ad hoc committee inquiries. I'm going to give you a very good scenario here. I was very much interested when I read in the clause. I appreciate the spirit for making this one, but then there was some omission that the amendment seeks to put in, and it is on subsection 4, which says that where the executive officer has been suspended under subsection 3, a caretaker manager shall be appointed by the registrar in consultation with the executive committee. That is what it is in the Principal Act. But then the amendment seeks to delete in consultation with the executive committee. But what do we have to say? Dear honorable members, the existing requirement for consultation does not operate as a veto over the registrar's powers, but it functions as a procedure safeguard that ensures appointments are informed by institutional knowledge, sector expertise, and stakeholder perspectives. This balance allows the registrar to retain final decision-making authority while still benefiting from the CMO's operational insights, ultimately safeguarding both governance integrity and rights holder interests. So removing this provision would centralize decision making entirely in the regulator, contrary to established good governance principles, and would eliminate the important check that helps prevent arbitrarily influenced appointments. So we recommend that subsection 4 of section 74 be retained in its current form, preserving the requirement for the registrar to consult with the executive committee before appointing a caretaker manager. Such consultation is not intended to serve as a veto, but rather a procedural safeguard. What is interesting in this particular provision, that as you go ahead, I think it is in subsection 5, where it says in the amendment that the caretaker manager will be appointed on the same salary band as the suspended manager. Is it what it says? Yes. There's a precedent that happened at UPRS. That's why I want to give you this background so you get to appreciate it. The regulator took over and suspended the manager. And then they appointed a caretaker manager without consultation with the members. And that is what caused the agitation for the past 5 years before we sat down to amend our own constitution, the society constitution. And when this caretaker manager was leaving, he demanded for a lot of money from the regulator. The regulator was pushing back that, no, you go back to UPRS. And the caretaker manager was saying, no, UPRS did not hire me, you hired me. So I understand the spirit where that particular clause comes from. And they ended up paying a lot of money to this caretaker manager. So while we regulate, I beg that the Uganda Performing Rights Society respectfully calls on Parliament to amend the Copyright and Neighbouring Rights Amendment Bill 2025 in a manner that aligns with Uganda's constitutional principles, international treaty commitments, and the practical realities of our creative industries. In conclusion, the choice before Parliament is clear. Either enact a law that empowers Uganda's creators and attracts investment, or risks stifling the very industries that carry our cultural and economic future. Thank you. I submit.
Thank you, Mr. Nkoyoyo, for the very wonderful presentation. I'm personally amazed by your depth of knowledge in your industry. Thank you so much for being so deep-rooted and giving us that wealth of information that, of course, will be very, very useful to the decisions that shall be made by this committee. I want to invite, I think, restrict only Honorable Salirwa to weigh in, and then we do conclusions in the interest of time.
Mr. Chairman, I want to thank you, and I want to thank Mr. Nkoyoyo and the team for a very detailed and penetrating discussion. First of all, I want to comfort you that as members of Parliament, we will do justice to your views. And just to remind you that this particular bill was initially brought by some of our colleagues who are MPs. The Honorable Hilary Chiyaga, supported by the Honorable Rachel Magola. Eventually, government took it over. So we are very passionate about it, and we associate with this bill because it was brought by our colleagues. So I want to comfort you that we will try as much as possible to ensure that your views and your interests are captured, because we also your representatives. So when government took it over, they brought it here to us to scrutinize and listen to all of you. So these views that you've given will form part of the report that we are going to make and then submit to the entire House for all the other members of Parliament to have an input, because we are merely a committee of the entire Parliament. But as far as we are concerned, as members of the Legal and Parliamentary Affairs Committee, we will do justice. So I want to comfort you in as far as that issue is concerned.
Thank you.
Secondly, Mr. Chairman, just a few clarifications that I intend to seek from Mr. Nkoyo and the team. You seem to express discomfort with clause 5, which is amending section 13, registration of contracts. And you are saying it should be optional. I want to understand what would be your discomfort in having the contracts of assignment, license, and transfer registered. Where is the problem? Where do you find the discomfort? No,
Mr. Nkoyo, hold on. You note them down.
Yes.
You respond at once.
Yes, because my understanding is that registering has more advantages than disadvantages. And I speak from a professional point of view as a practicing lawyer, not necessarily as a creator. Maybe we may have different perspectives, but just to understand why you would be uncomfortable with the requirement for registration. Number two, Mr. Chairman, is on the issue of reversion. Clause 6, reversion of copyright. You also seem to be uncomfortable with capping it at 20 years. And in your view, this copyright should exist in perpetuity. That's how I have understood you. I am not so sure whether there is international consensus on making it open-ended. I'm not so sure. Because I am aware of certain countries where actually reversion is capped. I'm aware there's some jurisdictions actually cap reversions. Here there is a proposal for 20 years. Your view is that it should not even be increased or decreased, it should be scrapped. I also want to understand your discomfort in capping the reversion of copyright. Thirdly, Mr. Chairman, is just to make a few clarifications from my part on the issue of rules. When you were discussing clause 12, amendment of section 41, the quasi-judicial powers of the registrar, you seemed to be uncomfortable with the regulations as opposed to specific provisions in the Act. And for example, you are saying that the statutory procedural framework should actually come in the Act itself and not necessarily in the regulations. Again, speaking from experience as a legislator here and as a lawyer, you should not worry about that. When Parliament decides to divest some of its authority to what we call subsidiary bodies to make regulations, we are not in any way diluting an Act. But you see, at the same time, an Act cannot be impregnated by everything. An Act has limitations. There are things that we reserve for the Act, and there are things that will come from what we call subordinate legislation. But even when we create or we empower either minister or an agency to create subsidiary legislation, we give it the same force. Okay? For example, it is possible for a regulation to create a fine. It is possible for a regulation to create a punishment. So you don't have to worry where it is placed. I think what is important is that, because you see, even when Parliament empowers a minister to make regulations, they guide that minister on those aspects that the regulations should cover. So if tomorrow, Mr. Nkoyoyo, this act comes out and this particular issue is not reflected in the act, but the act is empowering the minister to make regulations to cover that, it will have the same effect, it will have the same force of law. So I thought that should not bother you. It is something that we will ensure. Chair, there are issues again that you will not make a subject of legislation, either principal or subsidiary. And here, for example, you cannot say you include a provision in the act of recusal, automatic recusal. It will not happen. It will not happen. The recusal will happen, but it cannot be as a matter of law. So if you are uncomfortable with a presiding officer in either a judicial or quasi-judicial body, then you make a formal application to him or her, giving reasons why they should recuse from a matter. So it cannot be direct, okay? Otherwise, you are going, first of all, you are going to create assumptions that when somebody takes a decision, they are definitely biased or they are conflicted. And with due respect, which would be unfair, I think we should do, because whether you state it in the law or not, where somebody has discomfort in a presiding officer or judge, they will make an application for recusal depending on the reasons and circumstances. Okay? So, because here I was seeing our brother saying that, you see, there should be express statutory duty of a registrar to recuse themselves. Okay? This is a legitimate concern, but it cannot be statutory. It cannot. And this does not take away your right to ask an officer to recuse themselves from a matter. So I thought we would make that clear. It also applies to the issues of the ones you are saying that orders of the registrar should be stayed pending an appeal to avoid prejudicial enforcement. You see, again, you are not going to deviate from the conventional principles of law. An appeal per se does not operate as a stay. And the chair here is a distinguished lawyer. If you want a stay, you make an application for stay. It's really as simple as that. Okay? So there is not going to be an automatic stay simply because you are making an appeal against the orders of the registrar in his or her quasi-judicial functions. And these are things that are already established in our judicial practice. So just don't get worried about them, okay? They will come and they will indeed help us. Now, Chair, I think the second last issue that I'll raise, no, it's not the very last issue. You know, this bill here, one of the things it is doing is domesticating. It seeks to domesticate many international conventions of which Uganda is a party. In fact, Chair, for me, one of my reasons for supporting this bill is that Uganda as a country has international commitments and obligations. We agreed. We willingly signed these treaties. Now we have a duty under this law to have all those treaties domesticated so that they become part of our law. Now, once we have them domesticated, it means that we must align all our laws to suit those international treaties. We must align them. Even where there are laws internally, Chair, that conflict with those treaties, we have an obligation to change those domestic laws to satisfy the provisions of these treaties. So that is something I think that we need to highlight. We have an opportunity, and there are really very many, as he has highlighted them and as others have highlighted them. So it's important that we should not even be looking at just certain provisions within these treaties, but the entire provisions in the treaties. We have a duty to domesticate every provision. And you see, Chair, I know we always make a mistake, and I was discussing with our legal team here. You see, in the law of treaties, once a country willingly and voluntarily signs a treaty, we are bound by it. If there are laws in our country that conflict that treaty, it is up to Parliament to change the laws to ensure that they match with the treaty. In other words, and I don't want to take you into a lecture of international law and treaties, but I've been telling colleagues that, in other words, international law is superior to domestic law, what people call domestic law. But technically here it is called a municipal law. So international law is superior to municipal law. And the International Court of Justice has said in several cases that they call advisory opinions, that a country cannot hide under domestic law to circumvent its obligations under international law. So when you enter, and if there's a provision in a treaty you are uncomfortable with, at the time of signing you say so. It is called the reservation clauses. Okay? The Muslim countries, the Arab world, when they are negotiating treaties and the UN, especially those that relate to families, women, they always express reservations because they are very clear. We Muslims are very clear. We don't sign a treaty that, for example, says monogamy is the only thing. We will not sign it. So you'll find the countries in the Arab world saying, no, that particular clause will not bind us. But they will do what? They will sign. So you reserve. It's called the reservation of treaties, reservation clauses. So, but in our case as Uganda, Mr. Chairman, I have researched. We have not had any reservation clauses in any of these treaties. We have not had any. So what that means is that these people, this team here, are right to hold us as MPs accountable to ensure that all the provisions of these treaties are domesticated. I thank you, Mr. Chairman.
Thank you, the Honorable Haji Asman Vasari Vasalongo. I already expressed from the beginning the depth of knowledge Mr. Nkoyo and the team exhibited in their presentation. I have a concern where you express, not explicitly, lack of knowledge by the beneficiaries of this law, and you demand for plain and simple language in the drafting. I expected Jasman to hint on it, that there are minimum standards in legislative drafting that must be adhered to. So we may need it to appear as plain as possible, but we may not go below certain standards. And just like we cannot assume total knowledge about the creative industry, and we seek a lot of knowledge from you, we always implore many artists where they are lacking in knowledge in a particular area, if it's legal, to get the services of lawyers to give them a proper interpretation of some of these clauses. So we may not be very categorical on the plain and concise language as you want it, because there are standards of legislative drafting. So I wanted to make that clear. Now, on the issue of a caretaker, there seems to be a scenario where a caretaker may be needed in the circumstances. Now, for avoidance of repetition of the scenario that you alluded to, why would it be convenient to suggest a time frame within the caretaker can act maybe and say should not exceed 6 months or this particular period of time, so that
that is actually provided for in the law.
Yes.
It is 3 months.
3 months.
Yes, that is the timeline.
Oh, okay. Then I know in so many instances and so many companies limited by guarantee, especially where we have board members masquerading, and I will use that word deliberately, as volunteers, there is always an inability. There is always an inability to call annual general meetings deliberately. And so the purpose, and I put it in quotes, please don't misquote me. There's always a deliberate attempt by the people in leadership to deliberately fail to call annual general meetings. And the spirit of this provision is to ensure that there is adherence to the requirement. You see, when you assume a responsibility voluntarily, then it must come with obligations that you must meet. So I really wanted your a more honest opinion on the issue of annual general meetings and failure to set. We may look at the penalty as too harsh, but leaving it plain also creates other problems that the Act is trying to run away from. And so it creates a challenge. And then lastly, the Honorable Asman talked about the statutory safeguards. I wanted also to allay your fears that not everything will be in the law, but certain things have been adopted generally by operation of the law, by legal practice and so many things. So I want to allay your fears. We seek knowledge from you because this law is your law. So wherever it is lacking, we expect you to enrich us deeper. And we assume that the Attorney General has also made a lot of comparisons, that if you give us the information, then we get an opportunity to do a comparison and see what is best for the industry. This is your industry. Whatever you suggest, we take it very serious because you know it more than we do. And so we take these recommendations you've made very seriously, and there will be a very, very instrumental guide when we are making decisions that we shall present to the floor of the full House to adopt. We make a very persuasive report, given the fact that we have heard from the real owners of the law that it intends to benefit. I want to give you only 2 minutes to respond to some of the concerns that the Honorable side, and I'm very strict on time because only 2 minutes. The issues he raised, he knows the answers, and I also know you know the answers, so I'm giving you strictly 2 minutes so that we close this up and have another team.
Let me thank you, Chair, and let me first react to your very last concern about the annual general meetings. We are not saying or justifying that the executive committee should not be held accountable for the annual general meeting, because actually when you look at the Principal Act, there are already provisions taking care of that what happens when that happens. And I did raise in my submission that the point is not the lack or absence of the law. The issue has been the lack of the enforcement of the law. We are saying if we go past our 12 months, past 3 months after the calendar year and we've not held an annual general meeting, we are not saying we should not be held accountable because we've made a commitment that we shall host it. But there are provisions in the law. I implore you to take a look at clause 7 of subsection 7 of section 70 of the Principal Act. It is already catered for there that what happens when an annual general meeting does not happen. Yes.
So look at the provisions of the Companies Act in line with this?
To be true, in line with this, no, I did not.
Okay.
Yes. Then, away from that, I want to thank Honorable Basalirwa. Thank you for building our confidence on the domestication of the international treaties. Because so many times people think we can act in a vacuum or like as if we're on an island. So we thank you for the confidence that you built in us about the domestication of the international treaties that we are part of. Then on the quasi-judicial powers, Honorable I implore you to actually, my own personal recommendation would be to repeal that particular provision. But then from discussion with colleagues, it's a collective, they said, no, we can perhaps have it, but then, because it has a real danger, and the real danger is the conflict of interest. As I did say, Honorable, that remember the registrar is not a neutral standalone body, but the registrar is still the one who regulates, so they are going to become the judge, and then they become everything. So there's going to be a very, very big conflict of interest. So I still implore this House that please, when looking at that particular clause, pay close attention there. Maybe it may necessitate going into a little detail on what should happen and what should not, if you so choose that it should stand. And then finally, on the reversion, where is my discomfort? My discomfort is in what you very say, the international treaties. And then internationally, international foreign investment, big time investors, they need to have the sense, the feeling that, there is longevity. Because, for every formidable businessman, they don't plan well hoping that they will get their return on investment immediately, but they plan in the long term. And then also, secondly, is that the fact that I implored you to look at that, if you go to a piece of land, and why should it be with only our property, the intellectual property, that should have a cap? Why don't we have a cap that if I bought your land, I only have it for 20 years, and then it is reversed to you, back to you? So there's something you need to look at very critically there, and that is embedded in, as I did quote in the Principal Act, that we may look at it as movable property. And then lastly, you also asked about where is my discomfort on the registration, on the mandatory registration of our contracts, our works, and what have you with the registrar. Let me still begin with using the analogy of land. We all know that the legitimate certificate that shows that you are the rightful owner of a piece of land in Uganda is a land title. We agree. Does that invalidate that if you sold land to me and we made an agreement, does it invalidate it? No, it does not. Yes, but that is what we are saying. We are saying, we are not saying do away with the registration, but we are saying do away with the mandatory. We are saying create incentives, just like one would know that, hey, I'm safer with a land title than with just an agreement. Because this, why do I call them formalities? Even the registration alone is not coming free of charge. It's coming with a cost. Am I right, members? They all know. It is coming with a cost. So those are the formalities. So when you look at the cost of producing something, and then when you look at the international treaties we are talking about, WIPO says creation, what gives you ownership to a copyright? It is creation, not registration. That is what it is. That is the principle we are pointing to. And we are saying, let this be optional rather than mandatory.
Thank you very much. Thank you very much. Thank you very much, Uganda Performing Rights Society, and then the whole team. Thank you for giving Mr. Nkoyo the support to make a very wonderful presentation, which we have all benefited from. We have allayed your fears, and we continue to give you comfort on the presentations you've made. I want to excuse you, and we have another team take up.
Thank you, though I did say that we're also members of this team.
Okay.
Yes.
We will ask you to get at the back and then allow the people who are to make the next presentation come at the front. I think let's have the Uganda National Musicians Federation making their presentation. I want you to clear that table for Uganda National Musicians Federation. For those who came in later, we have invited you for a cup of tea or water, whatever you find very close to you. Okay, let's call the meeting to order. Good afternoon, ladies and gentlemen. Good afternoon. My name is John Taylor. I am a member of Parliament representing Bugabula County and North from Kamuli District. I'm the Deputy Chairperson of the Legal and Parliamentary Affairs Committee, and I'm chairing this session today. I have two colleagues here. I will only ask them to introduce themselves, specifically those two, because they seem to be more knowledgeable in what we are dealing with now.
Thank you, Honorable Chair. Robert Sekitoleka is my name. I represent Vamunanika County, Luwero District, and a member of this committee. Chair, I look express conflict of interest. Have Mr. Kajubi here behind, who is my voter and a serious supporter. So that I've expressed it, Chair.
The Honorable Sekitoleka is a member of the National Unity Platform.
Mr. Chairman, I thank you. My name is Vasali Rasman. I am a member of Parliament, Bugiri Municipality. I am a member of this committee.
He's also a member of the Justice Forum, JEMA. You forgot to add that he's a Salongo. Now, I'll ask the team leader on the other side to introduce himself and the rest of the team, and then we will straight away receive your presentation, and then we'll make it interactive after.
All right. Thank you, Honorable Chair. My name is Michael Kalumba. I am the Chief Executive Officer of the Uganda National Musicians Federation. Honorable Chair and the honorable members of the committee, present before you today are the members of the Uganda National Musicians Federation. The Uganda National Musicians Federation is a nationally recognized umbrella for...
just a second. Yeah. You know, these are very important people in this country. I want you to give them an opportunity to introduce themselves.
We have 25 member associations within us. The president and the senior presidential advisor is away on official duties, but on the front line today, we have the vice presidents with us. That is Shiba Karunji.
I will insist that they introduce themselves.
Oh, okay.
Please. Thank you.
Good afternoon, everyone. I'm so honored to be here. This is our fight, and I'm sure every musician, every creative is so happy we are here.
Shiba, in
under the
Parliament,
front
there are rules of procedure.
Oh,
when they say introduce yourself,
that is it.
you are introduced.
We are new to this.
Thank you.
Sorry, we'll get there. Shiba Karunji, Vice President, UNMF. Thank you.
My name is Palaso Pius Mayanja, Vice President, UNMF.
I'm Lillian Babazi, and I am the General Secretary, UNMF.
My name is Mhumza Martin. I'm the Director of Research and Development at UNMF.
My name is Lyonga Uzail, Assistant Director, Research and Development, UNMF.
Yes, my name is Sawanyana Malcolm James, and I'm the Chief Administrative Officer, UNMF. Thank you.
Thank you, Honorable Chair. My name is Agaba Ezra CJ Champion, Coordinator Western Uganda, and I also work in the Office of the President. Thank you.
My name is Joe Steady, Kampala Central.
My name is Caretaker John, and I am the Chairperson, Songwriters Association of Uganda.
My name, I'm Seruga Fred. I'm a member of the Federation UNMF.
My name is Muzira Stephen, Coordinator Central Region and Secretary, Greater Mukono Association.
My name is Rwanga Sulaimani Khalifa Haji, Board Member.
I am Mama Halima Namakula. I am the head of Women Affairs, UNMF.
Thank you very much. Do we still have other members who are supposed to introduce themselves?
Thank you, Mr. Chair. I'm called Morgan Isaac Maganda. I'm the Chairman, Central Musicians Association, Kampala Metro.
Good afternoon, honorables and everybody here. My name is Chigundu Bruno K, and I'm the Chairperson, Mukono Musicians Association.
Yes, Chair. Council Muyinda Rama, Research and Development Officer.
Yes, thanks, Mr. Chairman, and our dear MPs. I'm Coco Finger, representing Northern Uganda from the UNMF.
My name is Kemikisha Mariam, known as Lady Mariam Tindatin, from Western Uganda, UNMF.
Good afternoon. My name is Raymond Joseph Mugera, aka Ray Signature. I'm on board of UPRS and I'm part of UNMF Mukono. Thank you.
Thank you very much. I guess we've heard all the introductions. We'll hand it over back to you. Now, the purpose of today's meeting is to get your input on the proposed amendments in the law that affects you directly, because this is where you derive your livelihood. We as members of parliament are not exceedingly knowledgeable in this area, but we seek further knowledge from you, the industry insiders, to enrich this law so that once parliament passes it, it's for the benefit of the people who benefit from the industry. So the purpose of your coming here today is to give us additional knowledge and information in relating to the law. And so we invite you to make your presentation. You may not go verbatim since we have a written document, but we will ask you to highlight the key areas that you feel must be brought to the attention of the members of parliament in their decision making upon this law. So may I invite you to make your presentation, please.
Thank you, Honorable Chair. We participated in the nationwide consultations, and also we've been in touch with the process. Through the consultations, we made several agitations, what we would like to be included in the law, and we would want, our position would be 100% inclusion, but we also understand their limitations, both procedural and financial. After the draft came out, we've been in touch with the process, and we really ought to find out why some agitations did come out the way we wanted them to. We also understand the process is a long one. Honorable Chair, as direct beneficiaries of this and the receiving end of the act, our humble appeal to your committee and Parliament is to help this community, the musicians, fasten the process rather than derail it. Our colleagues, our earlier colleagues here really were on point in making other agitations. But we have a position as the Uganda National Musicians Federation, because as you had the introductions before you, Honorable Chair, we have an opinion and we are in full support of this bill as it is, and commend the Ministry of Justice and Constitutional Affairs for introducing these amendments that address critical gaps in the 2006 law, adapt to technological changes, strengthen revenue sharing mechanisms, improving the regulation of collective management organizations, and align Uganda with the global corporate standards. Honorable Chair, like I noted, we are in full support of the bill as it is. Also understanding that there are some eliminations that were made at some levels. I would like to invite my colleague, the Director of Research, to highlight a few observations that we made at the UNMF.
Yeah, thank you, Michael. Honorable Chair and members, I thank you again. I'm Martin Muhumza for Research and Development. Like my colleague said, we are in support of the bill as is, but we understand that in most cases laws are passed, and when you read the law, it is very beautiful, but it isn't doing anything. It's not, the implementation is low, and that's why we recommend that we understand that there is rationalization of government and creating of new agencies, authorities is going to be a challenge as of now, but there is already a Directorate of Copyright and Neighbouring Rights in URSB. We request or we pray that this committee sees it right to empower it more in the law so that it carries all the responsibilities concerning the copyright protection and everything around copyright. It should have that power from Parliament. It will help because we are not creating a new law for this. It's already there, so we just ride on the resources in URSB, and then we look into staffing it the right way, looking into who should be where, and that will also answer our colleagues' problem of the fear of conflict of interest if we have a directorate working on that. Then another challenge is understanding. A lot of our colleagues don't understand these laws. There's a lot of ambiguity going on. The definitions of these words in these laws, sometimes we don't know, someone doesn't understand what a phonogram is. So we need to have clear interpretation of these words. We shared an annex there of some of the most used words in the creative industry, and their definitions, but with your wise counsel, you'll add more or explain more. Another issue we are looking at, we appreciate the fact that for the past 15 years, CRBTs has been just something in the air. No one was regulating it. The telecom companies were doing as they deemed fit. They would imagine the creator of these works was receiving only 1.8% of the revenue collected. But we thank government and colleagues who were part of this, and you, the members of parliament, for lifting this. At least the percentage is now clear, and we hope that it stays that way, because I'm sure sometimes when you go back to the committees, you reduce. So it's, please either add more or maintain that. Please don't repeal. We love that. We appreciate the enforcement of the digital protection and enforcement in clauses 6, 13b, and 17, because the reason why we are all advocating for the amendment of this law is that there's a lot that has come since 2006. New streaming platforms, there's a new domain that has come and it's very busy, the digital content creation, and without the digital protection, those people are just working in the dark and they're losing a lot of money. So we commend you for that. Like Chair said, we are going to be brief. We appreciate the fact that Honorable Basariro has lifted our confidence in mostly the domestication of these treaties, the Berne Convention, WIPO Treaty, and other, the Marrakesh Treaty and others as listed there. Because at the end of the day, we are operating in a global village where you create a song or a film, and in just 2 days it can reach wherever. So if we don't create those reciprocal understandings with the world, that means we are building our own island, and we thank you, Honorable, and your colleagues for this. We hope we continue to support each other on this. Now, back to our colleagues not understanding or knowing what the law is about. We want this law to work, because since 2006, when it was last amended, I don't think it has done much. Yet its provisions would also do some, would protect some rights, but because people didn't even know what it means, we had that gap. So we pray that national sensitizations are done. At least if we can have major 5 or 4 per year, so that our people understand what they're dealing with. Because at the end of the day, we are going to have a lot of, sorry to use the word, noise made. And when you sit with a person complaining, you'll find out that it's just a matter of not understanding why they're arguing. So before we know, we'll have conflicts in court that we don't even know why we are putting them there. So we pray that this be considered. So as we design, or as you empower the Directorate of Copyright, this should be one of the major issues. Otherwise, you're not going to regulate anything.
Whose responsibility should that be?
That should be a responsibility of government, because it's your responsibility to make your citizens understand. You'll correct me if I'm wrong, but that's what I know. To understand what you are legislating, because creating a law where we don't know, because you guys sit here and make laws every day. A lot of them, the last I checked was about 300 plus. And very few Ugandans know about them, but they are regulating Ugandans. So for this particular one, we request that government creates something that helps us understand it more. And this awareness will help. We need to create these campaigns, and not just creating them the government way, because government will come and put something on TV with a man in suit and leaves. But we should understand the environment we are dealing with and how we communicate to them, so that someone doesn't get bored of the copyright story. So yeah. I think that's more of it. The rest proposed definitions in relation to the international practices. And I thank you, Chair and colleagues.
Thank you very much. Do we have anyone who wants to supplement on that? Okay. No one? Oh, there's a hand there.
Thank you, Chair. I would love to thank Mr. Martin Muhumuza for the presentation, but would love to get directly to what Honorable Asman Rasaya talked about the fear in the registration of contracts.
He hasn't responded to this presentation as yet. Okay. So don't preempt him.
Please.
Any other? Okay. Thank you very much. I'm amazed by the you know, these conflicts always bring us to dig deeper. So you seem to have a divergent opinion on some of the provisions from the Performing Rights Society, right? If I got you clearly. For you, with as for the law as it stands here, save for the few highlights you've made here, like awareness to the beneficiaries of the law. Okay. We have very senior presidential advisors who are also in the industry. Isn't that sufficient awareness? By pulling them closer to government and then they tell others? Can I respond?
Yeah, and for information, one of them is our Muko here in Parliament.
We even have in-laws.
Yeah.
We have quite a number of presidential advisors who are in the industry.
One of them is the Muko in Parliament and also our president at UNMF. But you see, we should not forget that they are also in our industry, they are working. So if they don't have a budget for that, they're not going to send themselves to field to do that.
That's one they should raise it to the appointing authority. But anyway, I get your point. So, but you see, the beauty about this industry is that it's rapid emerging. Every day there is something new that requires attention. So if you look at the law, has it catered for the emerging trends?
That's why we commend the digital inclusion, because most of the things that are coming now are digital. We are very soon we are going to come back arguing about AI. Yeah, but that's another discussion. So I think with this digital inclusion, then we go back to the Minister for Regulations.
Okay.
Yeah.
Well, amazing. Okay. You agree with the law? Thank you very much for coming. We now allow you to take leave. And thank you for your presentation.